Welcome back to session 2. When we just broke a minute ago, we were on the items that will show you when you cannot use deadly force. To give a small recap of that, one of the reasons when you cannot use deadly force is because of a simple assault. You can't use it for a simple assault. It's got to be a felonious assault. You also cannot use deadly force because of violent language. We covered that one. Now, also because you're a victim of past violence and you fear future violence. That's not a reason to use deadly force because we said in the beginning, there must be an imminent threat. Imminent means there's a clear and present danger right now. The person has the ability, the means, and the intention to hurt you right now. So it can't be something that happened in the past or it might happen tomorrow. It must be an imminent threat, present danger right now. Now, also, too, you cannot use deadly force because a trespasser refuses to leave your property. Now, we're talking about property outside your home, in your yard, in your garden or whatever, your garage, not where you're living at, but you cannot use deadly force because somebody's on that property trespassing. As a matter of fact, let me say this up front. You can't use deadly force for anybody just for trespassing on your property. If you cannot use deadly force, you cannot even point a weapon at that person. If you do, you're committing what we call now assault by pointing a weapon, which is also a criminal offense. So do not point your weapon at anybody you cannot legally use deadly force against, or you are committing a felonious or a criminal act, rather. So you have a trespasser, what do? Call 911. Call law enforcement, let them do their job. Don't go outside to engage a trespasser if you don't have to, people. Put yourself in danger or a danger of using deadly force against that person. They're just on your property. Whatever they're doing is not worth going to jail over. So not because of their presence. Now, in some states, you can use deadly force against a trespasser. For example, Arizona and Texas. When I was stationed in Tucson, Arizona, we were 90 miles from the Nogales-Mexico border. They have big borders out there that police cannot patrol, don't have the manpower to do so. So they have the right, they can use deadly force against trespassers in those states, and they often do. But you cannot do that in North Carolina. Also, to arrest a criminal, prevent a criminal's escape. I don't care what you saw on TV about citizens' arrest from on the Power Show or whatever you saw it on. There's no such thing in North Carolina as citizens' arrest. Now, you may have heard the story of in Georgia. Georgia does have a citizens' arrest policy in that state. So they can do citizens' arrest. But one of the last incidents where it happened at was this father and son who attempted to do a citizens' arrest against a person for going into a house under construction, then jogging down the street from their house, and they got in their pickup trucks, and the son had a shotgun in the truck with him. The father had a handgun in the bed of the truck, had a person driving along behind them recording and trying to hem this person up, which is illegal because in order for this to be effective, you must have witnessed a felony that took place in your presence. To go into a house under construction is not a felony that calls for use of deadly force or anything else. This father and son were totally out of place trying to arrest this person for going into a house that people have all gone into before. And now he had no business in that house. He didn't own the property. Let me say that up front. He should not have gone in the house. Let's get that up front. But he should not have died because he went in the house, because somebody was overzealous trying to do law enforcement's job. Again, in North Carolina, you do not have a right to arrest a criminal or detain a criminal or anything else. Let them leave. Don't try to, and be a good witness. Describe the person, tell what they were wearing, which way they went, what car were they driving. That's the most helpful thing you can do. Do not try to arrest a criminal. Have people gotten by with it? Absolutely. They got by with it because nothing happened and wound up looking like heroes, but I'm advising you it is illegal to do so. Also, this may not sit right with some of you, because some of y'all love your stuff. You cannot use force to protect property. Let me say it again. You cannot use force to protect property. Your belongings are property. Your money is property. Your brand new car is property. Your motorcycle, your ATV, your lawnmower, that's all property. You cannot use deadly force to protect property. You can't even pull your gun and point your gun at somebody who's getting your stuff, because that's property. You cannot use money or deadly force to protect property. Let's get that straight. Let me say this also. Can you use deadly force? Some of you, how many of y'all got pets? I'm sure you got little pets. So you got the little poodles and the little teacup dogs, and you love them to death. And to use a person, unfortunately, law enforcement is not considered a person. And some of you would injure somebody seriously if they bothered Fifi or whatever animal you have that you love dearly. But let me tell you, by law, that animal, it does not warrant the use of deadly force because they are not a human life. Now, let me say this though. If you walk your little teacup poodle or your little apple-headed chihuahua down the street, and here comes two big Rottweilers, one bull mastiff, and two pit bulls over the fence at your little dog, can you use deadly force in that situation? Absolutely. But when you write the report, you didn't do that to protect little Fifi, your little apple-headed chihuahua. You did it to protect yourself because your life was actually in danger from those vicious dogs trying to get to your dog. That's why you use deadly force, not to protect your dog. So again, you can use deadly force in that situation because that breed of dogs do pose a threat to your life, and serious injury or death can occur from their vicious attacks. Don't hesitate. Defend yourself in that situation. This is what we call statutory law, and we call it the Castle Doctrine. Came about in 2013. I've just alluded to it already. But in your home, your workplace, your motor vehicle protection, there's a presumption of fear of death or serious bodily injury. You can use deadly force in that situation. Again, you don't have a duty to retreat in those situations, in those places. The lawful occupant of a home, motor vehicle, or workplace is presumed to have held a reasonable fear of imminent death or serious bodily harm to himself or herself or another when using defensive force that is intended or likely to cause death or serious bodily harm to another if both of the following apply. Let's look at these things here. The person against whom the defensive force was used was in the process of unlawfully and forcefully entering, or had unlawfully and forcefully entered a home, motor vehicle, or workplace, or that person had removed or was attempting to remove another against that person's will from the home, motor vehicle, or workplace, which is actually kidnapped. And the person who uses defensive force knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred at that time. So if I'm in my home or you're in your home at 2 in the morning, you hear a loud crash in your back door, Miss Lady, you're home by yourself, and nobody's supposed to come to your house at the time of day, you hear footsteps down your hallway coming towards your bedroom at 2 in the morning, and you yell, "Get out of my house. I've called the police. I will shoot you." And they come into your bedroom and all you see is a silhouette in your door. That person you know poses a threat to you. You have a right to be fearful of being seriously injured or killed or sexually assaulted. I recommend you to use deadly force effectively in that situation. That is a reasonable fear of your life at that time. The citizen using deadly force under this statute does not have a duty to retreat prior to using defensive force. The presumption set forth in above shall be rebuttable and does not apply to any of the following circumstances. The person against whom the defensive force is used has a right to be in or is a lawful resident of the home, motor vehicle, or workplace, such as an owner or leasee. And there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person. The person sought to be removed from the home, motor vehicle, or workplace is a child or grandchild or otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used. Item 3, the person who uses defensive force is engaged in, attempting to escape from, or using a home, motor vehicle, or workplace to further any criminal offense that involves the use of or threat of physical force or violence against any individual. The person against whom the defensive force is used is a law enforcement officer or bail bondsman who enters or attempts to enter a home, motor vehicle, or workplace in the lawful performance of his or her official duties, and the officer or bail bondsman identify themselves or herself in accordance with any applicable law, or the person using force knew or reasonably should have known that the person entering or attempting to enter was a law enforcement officer or bail bondsman in the lawful performance of his or her official duties. Very important. The person against whom the defensive force is used has discontinued all efforts to unlawfully and forcefully enter the home, motor vehicle, or workplace, and has exited the home, motor vehicle, or the workplace. That is a notice you're present. Oh my goodness, I'm going to leave now. They turn to go. You cannot use deadly force against that person because there is no more now imminent threat. Self-defense and defense of others. General statute provides that the person is justified in the use of deadly force and does not have a duty to retreat in any place he or she has a lawful right to be, or if he or she reasonably believes that such force is necessary to prevent the imminent threat of great bodily harm to himself or another person. A citizen who lawfully uses defensive force in compliance with these statutes is immune from civil and criminal liability. General statute justification for defensive force, not available. Justification described in General Statute 1451.2 and General Statute 14-51.3 is not available to a person who used defensive force and who was attempting to commit or committing or escaping after the commission of a felony. Initially provoke the use of force against himself or herself. However, the person who initially provokes the use of the force against himself or herself will be justified in using defensive force if either of the following occurs. The force used by the person who was provoked is so serious that the person using defensive force reasonably believes that he or she was in imminent danger of death or serious bodily harm. The person using defensive force had no reasonable means to retreat. The use of force which is likely to cause death or serious bodily injury to the person who was provoked was the only way to escape the danger. The person who used the defensive force withdraws in good faith from physical contact with the person who was provoked and indicates clearly that he or she desires to withdraw and terminate the use of force. But the person who was provoked continues to resumes the use of force. So again, allow that person to disengage, and you disengage and do not use force in that situation. You must also store your weapons to protect them from access to minors. Very important. Any person who resides in the same premise as a minor, which is defined as a person under the age of 18 years old, who owns or possesses a firearm and stores or leaves the firearm in the condition that the firearm can be discharged and in a manner that the person knew or should have known that an unsupervised minor would be able to gain access to the firearm, is guilty of a Class 1 misdemeanor if a minor gains access to the firearm without the lawful permission of the minor's parents or a person having charge of that minor, and the minor does what? Possesses it in violation of North Carolina General Statute 14-269.2. It says unlawful to possess a firearm on any educational property, public or private, of any kind. So your little child carries your gun to school for show and tell, you will be in trouble with a Class 1 misdemeanor. That juvenile exhibits in public place in a careless, angry, or threatening manner that firearm, you'll be charged. Causing personal injury or death with it not in self-defense, then you will be liable for that also. Or using it in the commission of any crime, then you are liable as the gun owner. So store your guns safely. Lock them safely. Use the proper lock. Use safes. Use breech locks or whatever kind of locks you want to use. Make sure that weapon is not accessible to a minor. Definitions: conceal, carry, and handguns. Let's define what a handgun is, because this lesson only allows you to carry a handgun concealed. Let's see what a handgun is. A handgun is defined as a firearm that has a short stock and is designed to be held and fired by the use of a single hand. That's all it says for legal purposes, folks. It's designed by the manufacturer to be shot by a single hand. That's what it says. Now, under that definition, which is very broad, it allows for your AR-style handguns, your AK-style handguns, your shotguns that don't have a shoulder stock on them, such as your Storm and other ones that will fire shotgun shells of different calibers, pump shotguns and semi-automatic, because the overall length is limited to 26 inches. That's the max length for it. Also, if you're a rifle, the rifle max barrel length is 16 inches. The shotgun's max barrel length is 18 inches, as long as it does not exceed that, it is considered a handgun. And yes, you can carry those type weapons on your body, concealed with a sling, if you should choose to do so. And they will still take, and for the rifle, a box detachable magazine that may hold 5, 10, 20 or 30 round or 50 round drum. It's still legal under the law. And also that shotgun can carry several shells in it of different calibers. Popular gauges are 12, 16, 20, 410. Excellent for home protection. I recommend those type weapons to be used for home protection or just for the fun of shooting. So they are legal. Now the definition of a handgun has two characteristics in this state. First, the firearm must have a short stock. Second, the firearm must be designed to be held and fired by the use of a single hand. Revolvers and semi-automatic pistols are treated alike. It doesn't matter what's revolver or semi-automatic. Caliber or the firearm of the firearm is not specified. Doesn't matter what caliber it is. While length or configuration of the firearm stock is not defined, presumably it must be shorter than the standard rifle or shotgun. A judge might reasonable conclude that a standard rifle or shotgun is not designed to be held and fired with one hand, even if the rifle or shotgun has been cut down so it can be fired so like that. You cannot modify a gun yourself. If you do, you just violated the gun laws, and there is a problem with that. So federal and state firearm laws prohibit possession of a sawed-off shotgun or rifle. Whether you did it or not, if you possess that weapon, you are in violation. The law applies only to handguns. No other types of weapons like knives, clubs, or martial arts weapons are within this definition. So do not get a weapon, shotgun or rifle, and modify it yourself. It must be made by the manufacturer by serial number as a handgun. Conceal. You think that would be pretty self-explanatory. The statute further requires the concealed weapon to be about the person, which generally means it must be concealed either on the person or within arm's reach or within ready access to that person. If it is concealed by law enforcement definition. In order to carry a concealed weapon, there is certain required documentation you must have on you at that time you have a concealed weapon on you. You must have a concealed carry license and a form of ID, which your driver's license is sufficient, or a student ID will suffice also. You have either one of those documents missing, you are in violation of this concealed carry law. Now, a little caveat for you. If you find yourself, you lost your wallet, or you lost your concealed carry license, or your form of ID, and law enforcement approaches you, you just uncover the weapon. Uncovering the weapon is no longer now concealed because your garment does not cover the weapon, and the law does not require you to have any document to carry an open carry weapon. So you avoid a write-up by having the weapon now open carry. So just a sliver of cloth over the weapon made to conceal, uncover the weapon. Now you can't be written up for not having your documents. If you're approached by law enforcement, what to do if approached by law enforcement officers? First of all, foremost, do not attempt to display the handgun. If you got a handgun on your person, concealed carry or open carry, do not attempt to display the weapon. Look, sir, I got a gun. Very dangerous thing to do. You may wind up in a bad situation. If in a vehicle, roll your windows halfway down. If at night, turn on the interior lights, folks. Place both hands on the steering wheel. And once the officer approaches the vehicle, notify the officer that you have a permit, that you are armed, and where the handgun is located. A little caveat here also. Now, the state law just said roll the window halfway down. If you're in Nash County, Wilson County, Edgecombe County, they're going to want that window all the way down. They're going to tell you that because you have no way of knowing that because it's not in state law. It's a local ordinance, but it's a reasonable one because of officer safety. Somebody has tinted windows, a window halfway down in a big pickup truck with a 12-inch lift kit on it, you still can't see their hands, folks. So it's a safety issue. They're going to tell you to roll your window all the way down. Go ahead and do so. Follow the officer's instructions, and you'll be a whole lot safer. Now, also, too, if it's at night, turn your interior lights on in that vehicle. And also, place both hands where? On the steering wheel. Let me say it again. On the steering wheel. Do not put your hands out the window like you're saying, don't shoot. This sometimes antagonizes the police. It's an overreaction, overdramatic. Don't do these kinds of things. Keep your hands on the steering wheel and don't show any kind of attitude or disrespect toward the officer. And do notify them as quick as you can. If you do have a permit, you have a gun, a weapon on your person at that time and where it's located, just do not reach for it. If not in a vehicle, do not attempt to display the handgun. Keep both hands visible. Notify the officer that you have a concealed carry permit and carry a handgun. Now, what do I mean by this? Because you meet a police officer on the street and they're just greeting you, good morning, sir. You don't have to, sir, I do have a gun on my person. I do have a concealed carry permit. It's just a greeting. But they stop you and engage you in conversation where there's a significant time where they're with you, you must divulge the information that you have a concealed carry license, you have a gun on your person. But not because they greet you. Let's use some common sense here. Now, but if they do stop you to talk to you in a length of time, you are bound by law to divulge that you have a weapon on your person. Now, only attempt to remove the permit or the handgun on instruction from the officer. I told you earlier about furtive motions and furtive movements. Do not ever reach for anything in an officer's presence without permission and telegraph you're going to do so. When you do that, you put yourself in danger and also the officer in danger, and you may have a bad outcome with that. And also, don't reach for anything at all without permission. And when you pull that thing out of your pocket, don't just point it at the officer straight. Lower it and go toward him slowly with it. You come out in a furtive manner and point it at him real quickly. He may see that as a furtive motion. To prove my point, you go on YouTube, look up the Castle case. Mr. Castle was in a vehicle with his wife and little girl in the car, had a concealed carry license, a ID card with him. The police stopped him. And the police came to the car very courteously, said, sir, do you know why I stopped you? Mr. Conceal courteously said, no, sir, I do not. He told him you had a tail light out. So, sir, I appreciate it. I didn't know that. But so you know, officer, I do have a concealed carry license. I do have a weapon on my side, on the right side. And the officer very courteously said, that's fine, just don't reach for it. Says, no problem, sir. He asked for his credentials. When he reached, he was shot 4 times on camera. Shot 4 times, and the officer used the reasoning for he reached in a furtive manner, which is very subjective, and unfortunately he was killed right on camera in front of his little girl and his girlfriend, and he did everything he thought was right. So again, don't reach for your weapon. Also, in this context also, when it comes to your car, if you don't have a concealed carry license, the weapon should be on your dashboard and nowhere else. And if the officer just tells you, what type of weapon is that? You say, well, sir, it's my 1911 Smith & Wesson, special edition, gold engraved, walnut stock, bloppity bloppity blop. He said, well, they had one like that just stolen last night. Need to check, make sure that weapon's not stolen. Hand me that weapon. What should you do? Let me say this very quickly. Do not ever reach for a weapon in the officer's presence. In that situation, let them know, officer, I refuse to reach for a weapon in your presence. You may retrieve the weapon. I can get out of the car if you want me to, but you must retrieve the weapon. Even if it's on your person. And they have the right to always check any weapon to make sure it's not stolen. Do not resist that. But make sure that they retrieve the weapon off of your dashboard or out of your holster. Do not reach for a weapon in an officer's presence for any situation whatsoever. You run the risk of being shot. Escalation of force. Escalation of force. Let's talk about that. To escalate means to raise the level of something. When you go to the mall, you get on an escalator so you can go to another level. Well, we have what we call in law enforcement terminology, escalation of force, or a force continuum. I would advise you always to resolve this situation using the lowest level of force possible. So what does that lead to saying? I'm going to tell you, if all you have is a handgun to handle all your situations, you are not properly armed. You need other, less lethal means to your disposal, so you have some options to solve situations without just using deadly force. Some things may be, and take the initiative to do so. Learn some defensive tactics from somebody who's reputable. Now, everybody can't be like Bruce Lee. If you're already 65 or 70 years old, chance you're doing a roundhouse back kick is almost nil. Let's face it. Now, I teach concealed carry for senior citizens free of charge. I've done 2 classes in Nash County for senior citizens, live classes, and 2 classes also electronically through remote, and they really enjoyed it because I gave them things that they can do with their limited mobility and limited strength. Now, I do have some things you can get. There are all kinds of personal alarm devices you can use. You can order those things online. I will have some websites available to you to order those things online. I also taught a class at Shaw University twice to the female dorm. They were having sexual assaults up there, free of charge. Me and my partner went up there and taught Conceal, Cary classes and also self-defense classes for these young females in the female dorm. They really enjoyed it and taught them about these personal alarm devices. They give off a loud, audible alarm to alert anybody around you. Wake up half of that dorm if you need to. You can hear it across a Walmart parking lot, and they're relatively inexpensive. Also, pepper spray is a good option. Have it in your hands when you're in an area where you're more likely to be in danger, so you don't have to reach for it. Pepper sprays work very good. Are they 100% effective? Absolutely not. Nothing is. Also, there are tactical flashlights can be used. I have some samples of those I'll show you when you come to my class. Tactical flashlights, you can order those online. They give off a nice bright light that can be disorienting or illuminate the suspect, which deters aggression. Also, you switch a button on it, you got about 50,000 volts going to that person's body if you touch them with it. But it gives off a loud, audible crackling that psychologically disarms most people, or vicious dogs. So it's a thing to have in a low living-like conditions. It's very intimidating, and you use it, and the bad person or the assailant, so you're willing to resist, they usually go and find a softer target. So again, these are all items you can use. Also, batons can be used. Walking sticks, impact weapons can be used also. Anything is better than nothing. That makes sense? Any device is better than nothing. Any training is better than no training at all. All right? Now, but let's face it, the way you look can deter aggression, people. Some people, the way they look, some of y'all right now, looking at y'all right now, some of y'all looking at me under eye. You got a stern look on your face like, don't mess with me. Well, I've talked to many criminals, and they're very selective who they choose, how they victimize people. You ever see a lion on a safari, or a lion and he's hunting, he's stalking his prey, he sees a herd of wildebeest. What's he looking for? The weak, the inattentive, the young, naive one. That's the one he wants to get because it's an easier target. He don't want to grab the one with the full, mature horns and the big muscles. He does not want to fight. He wants a meal. And predators are the same way. I've had the pleasure of dealing with people who were guilty of victimizing people and talking to them and learning from them how they choose their victims. And they choose their victims basically the same way. Some of you all, I see this big fellow sitting over here. You weigh about 300 pounds. And I would not choose you because I'm about 68 years old. I got 2 bad knees. I would not choose you to assault first. I would choose you over here, weigh about $150, because I think you'd be an easier target. Am I always wrong? I can't be wrong. You may be a lot to handle, but I would choose my target based on size and possible strength. Now, but the way you look can deter aggression. So look confident. Be alert. Don't keep your eyes on your cell phone when you're in public. Know your surroundings. Keep your head on a swivel. Know your surroundings at all times. But also verbalize. When you talk to somebody about getting away from you, back away, say it like you mean it. Stop. Back away. Don't come any closer. Leave my house. Leave my property like you mean it. Okay, don't whisper it. Say it like you mean it with some assertiveness. Assertiveness is natural to some people. It's not natural for others. But try to get some assertiveness to get somebody off your property or off of you. Also, no matter how hard you try, sometimes it will not work. And sometimes that person is bound on assaulting you. No matter what you do at that point, it's going to be hands-on. If that's the case, you need to win the encounter. You understand that? There are what we call soft hand techniques. Punches, blows, strikes, that kind of stuff. Hard hand attacks. These are your punches, your blows. Your soft hands are your wrist lock, your takedowns, your arm bars, those type things. Also, chemicals can be used. Mace, OC spray can be used. These are irritants. They work very wonderfully. I've been sprayed with pepper spray, the good stuff, not the kind that civilians get, the good stuff law enforcement gets that will light you up. So when you spray it, your eyes burn, your nostrils burn, you forget to breathe, you're hacking, you can't even see. So it's very effective with most people and also for animals, but some people it doesn't even affect also. So it's not 100% effective anything you use as far as chemicals go. Impact weapons, they're close quarters type applications, batons, walking sticks, walking canes, those kinds of things. Sticks or clubs can be used. That's why I told the elder people the walking stick you carry is a baton if you know how to use the thing. And stick fighting is an art in itself in close quarters. It's very effective if you know how to use it. You can also employ deadly force with an impact weapon, A lot of folks don't realize this, but the impact weapon, a baton or walking stick, any strike above the collarbone in the front is a deadly force strike. In your sternum area, a deadly force strike. From the rear, from the head, from the head on down your entire spine, down to your tailbone, a strike with a baton is a deadly force strike in law enforcement terminology. So, you need to know that. And also, as a last resort, deadly force can be used. If you see deadly force is necessary because of the severity of the attack, a lot of times disparity of force, and multiple assailants, you better see that as a deadly force encounter very quickly. If that person is significantly stronger than you are, bigger than you are, more violent than you are, better trained than you are, you better see that as a deadly force encounter very, very quickly and use deadly force and be able to articulate why you use the force you use because of those factors. The increase in force does not need to follow these various levels. Depending on the level that is used against you, you and the imminent threat imposed against you will determine the lawful reaction to the situation. And you don't have long to determine this, folks. It's very quickly. You have to do this under duress in a compressed amount of time, and you'll be scrutinized by those who weren't there. So you have to understand before it happens. You can't call me at 2 in the morning and say, Mr. Williams, I got a problem. I got somebody beat me up, or some guy climbed in my window. Can I shoot him? You need to know that for yourself at that time so you can react. There's some areas where you cannot carry your weapon. Where you cannot carry your weapon. Some prohibited carry areas for your weapon. There are a number of areas where the carrying of a concealed handgun is prohibited either by state or federal law, regardless of and to issue the insurance of the concealed carry handgun permit. In other words, a concealed handgun permit does not allow a permittee to carry a weapon in these prohibited areas. The first one is what? Any educational property or private of any kind. So, this prohibition applies in or on any school building or bus, school campus grounds, recreational areas, athletic fields, or other property owned, used, or operated by any board of education or school board of trustees or directors for the administration of any school function. Now, this applies if the school leases the local Lions Club for a school event that becomes off limits for your carrying a firearm. Now, can you possess a firearm on school property? Yes, you can. In your vehicle with the doors locked. You can unlock the door long enough to let someone in the car or out of the vehicle, but you cannot just carry a weapon on school property. This just came about as of 2013. Prior to that time, you could not even possess a firearm on school property prior to that time. Now, if you leave your vehicle, you cannot leave that vehicle unsecured in that vehicle on school property. It must be in a locked container attached to the vehicle that's very secure, such as your trunk or a lockable gun box attached to the vehicle where it's not visible at all. A glove box on a school campus is not considered a secure location for a weapon because a glove compartment can be compromised even without a key. So even a locked glove box on a school campus is not considered a secure location on school property. Make sure you know this. You can't carry on any establishment where alcoholic beverages. This is the old law here. The law has changed since then. It used to be illegal to carry anywhere alcohol beverages were sold, consumed, or admission was charged. So this point here is actually obsolete because now you can carry where they sell alcohol and where alcohol is consumed as long as you don't consume one drop. You can't consume one drop of alcohol. It's not like driving is, where there's a percentage. It is zero alcohol, period, in your system with a concealed carry license. So you cannot have a gun in your presence with alcohol in your system. You can't carry concealed. But you can go into an establishment where it's sold or consumed, concealed only, not open carry, to get somebody out or do whatever you're going to do. It's legal to be there as long as it's concealed and you don't take one drop. North Carolina law also prohibits any person carrying a gun, rifle, or pistol into an assembly where a fee has been charged for admission or into an establishment, alcoholic beverages are both sold and consumed. We just clarified that. That is no longer the case. The law has changed where that is totally legal now. So if you see that on a test question, it is now legal to carry in a place where alcohol is consumed or a fee is charged but you just can't drink one drop yourself. So alcohol and handguns do not mix. And though the law does not forbid you to have alcohol, it's not a crime to have alcohol in your system with an open carry, I advise you not to do so. Also, you're not allowed to carry in certain state property, like courthouses, those kind of places. You can't carry in those buildings. I want to say this also, a lot of people don't know this, the Department of Correction or your Department of Public Safety, the Adult Parole and Probation has passed laws recently to where those officers who work in that field are certified to carry their concealed weapon, not like regular civilians are. They can carry theirs anywhere law enforcement can carry theirs once they issue that state license while they're employed by the agency. And this was done under the Patriot Act and the Homeland Security Act in order to have more people armed in this state who can respond to mass public shootings. And I'm all in favor of these folks get training every year. I train with them at the local colleges for their annual certification and their basic training. So their training exceeds what you do for concealed carry laws also. So, but they can carry anywhere law enforcement can carry where regular civilians cannot carry in courthouses and certain state property. Also, parades, picket lines, demonstrations at private health care facilities are illegal. Areas of emergency or riot, you'll find that it is illegal for you to go in an area where there's a declared emergency or riots taking place with your weapon. Now, this is very important, especially if you don't live in the area. If you live in the area, it's a little different than if you coming outside the area and with your weapon. Like we had happen recently, a young man came into an area he did not live in. His mother brought him there with an AR rifle, and it's very questionable whether that was legal or not with that weapon in that situation that he did not live in within a riot situation and wound up shooting 3 people. Now, the ones he shot were criminals, and when he shot, the shootings were legal under the law because his life was definitely in danger when he shot these people, whether people believe it or not. Now, his presence there is questionable. The shootings were legal under the law, but him going there is questionable. He may have an answer for that. So again, you don't go somewhere just because there's a riot or emergency situation with your firearm. You will be turned back probably. You're going to be illegal if you go through that area and you don't live in that area. Any federal property, including buildings, land, as prohibited by 18th U.S. Code 922 or any other federal law. So learn your federal laws. If you go into an area you're not familiar with, find out whether it's legal or not before you go there. For detailed information on this federal law, persons are urged to contact the Bureau of Alcohol, Tobacco, and Firearms or the Attorney General's office to get information on this. I advise you to research. Concealed handguns are allowed in federal parks in states in which the concealed carry permit is recognized. If they're not, they will have a sign stating such, but unless it's posted, they are allowed in these areas where in the past they were not allowed in those areas where you can't. Now you can carry concealed, I stress that only. Not open carry, but concealed carry. Posted signs on any private premises where notice that carrying a concealed handgun is prohibited by the posting of conspicuous notice or statement by the person in legal possession or control of that premises. So, anywhere that's posted, you cannot carry your weapon. There are 2 prominent signs we usually use. There's a circle with a hash mark with a gun in it, and one of them may say, no concealed weapons. What does that mean? I mean, you can't carry concealed weapons on that property, but you can carry open weapons on that, it's not forbidden. But if it says no weapons, period, you can't carry it open or concealed. I say that because some owners of these properties get this mixed up. There's a place in Nass County here, and if you ever go to, I'm going to name his name because it's very relevant, Dr. Cronkner's office, and you will see signs in there that used to say, no concealed weapons. But what he really means, he don't want weapons there at all. But I told him he need to change the signs because with that sign, somebody comes in with an open weapon, they're not violating his law. He needs to change that sign to read no weapons at all. But also it says it must be conspicuously posted so you can see the sign. Whenever you go to any building, look on the building, see if weapons are prohibited before you walk in there with your weapon. And usually conspicuous means what? On the front access door, on the inner door, before you get into property. I say that because in this local area here, at the Social Security office for a while. When I went to apply for my Social Security, which I did at 63 years old, I went in there, I'm looking, there's no sign on the outside door, no on the inside door. So I went in there, got my ticket, spoke to the security officer, sat down, read the bulletin board, and guess what's on the bulletin board? It says, no weapons allowed. I'm sitting with a weapon on, so how do you get out of this? Now I got to sneak out of here. So I just kind of waited for a while and nonchalantly got up and went outside and got rid of my weapon, came back in and told the officer, you need to have that sign on your outer door or inner door. He said, did you have a gun in here? I said, sir, I'm not going to answer that. I don't have to answer. Did you have a gun in here? Sir, I'm not going to answer that. But you had it on the bulletin board. When a person's already in here, that is not good for you or that person. And they still went about 2 years before they changed it. So again, have it conspicuously located. It may be a sign, it may not be a sign, it may just be in words. Such as at hospitals sometimes, they may say you must have on t-shirts, shoes, you must, no firearms allowed, no knives. Then you read it and you abide by that also. So, there are some prohibited carry areas. Okay, any law enforcement building, correctional facility, you cannot have your guns in those areas. Include county, municipality, university, police, or company police. You can't just carry your weapon in those areas. You are illegal. And an officer of the state of federal government that is not located in a building exclusively occupied by the state of federal government. Anywhere while consuming alcohol or any time while any alcohol or controlled substance in your blood, including improper use of prescription drugs. So you have a prescription drug you have that tells you do not operate a vehicle, do not drive cars, do not lift anything heavy, do not have a firearm, and you're caught with a firearm, then you're in violation of the law. Anything that impairs your judgment or your ability to function, do not have a firearm at that time on your person. Statewide uniformity. It is the intent of the General Assembly to prescribe a uniform system for the regulation of legally carrying a concealed handgun. To ensure uniformity, no political subdivisions, boards, or agencies of the state, not in any county, city, municipality, municipal corporation, town, or township, village, nor any department of agency thereof may enact ordinances, rules, or regulations concerning legally carrying a concealed handgun. A unit of local government may adopt an ordinance to permit the posting of prohibition against carrying a concealed handgun on local government buildings and their accoutrements or their premises. A unit of local government may adopt an ordinance to prohibit by posting the carrying of concealed handgun on municipal and county recreational facilities that are specifically identified by the unit of local government. If a unit of local government adopts such an ordinance with regard to recreational facilities, then the concealed handgun permittee may nevertheless secure the handgun in a locked vehicle within the trunk, glove box, or other enclosed compartment or other area on the motor vehicle. For purpose of this section, the term recreational facilities includes the following: a playground, athletic field, swimming pool, or athletic facility. Obtaining a concealed carry permit. So how do you get a concealed carry permit? It's very simple. In order to obtain a permit, the citizen must apply to the sheriff's office within their county of residence. You must live in that county. The sheriff also shall issue a permit to the applicant if the applicant qualifies under the following criteria. The applicant is a citizen. Each one of you now, while you're listening, listen carefully, because when you go to apply for your permit and you don't meet these requirements, do not call me for a refund. I don't give refunds if you don't meet these requirements. This is your responsibility. I don't do background checks. The applicant must be a citizen of the United States, has been a resident of North Carolina for 30 days or longer, immediately preceding the filing of the concealed carry application. Proof of citizenship should be brought to the sheriff's office. That's your responsibility. The applicant is 21 years old or older. 1 years old or older. Now, there is a provision for someone less than 21 years old to get a concealed carry permit if they are what we call an emancipated juvenile. Emancipated juveniles can apply for concealed carry licenses because they live in a home by themselves, they're responsible for themselves, so they can do that. They're less than 21 years old. The applicant does not suffer from any physical or mental infirmity to prevent safe handling of a handgun. That's up to your responsibility here. Applicant has successfully completed a concealed carry training course, has been approved by the North Carolina General Criminal Justice Education Training Standard Commission, and who instructor certified by this same commission as a concealed carry handgun instructor. So we meet all those requirements, people. I am certified. The curriculum you're getting now meets those requirements also. Applicant must submit the original certificate issued for the course to the sheriff's office as part of the application process. You cannot duplicate the certificate or run copies of it. It is illegal to run copies of that state certificate. So, if that's your situation, you can apply for your license. Now, if you know you're America's 10 most wanted and you're going to apply for your license, they turn you down, don't call back for a refund. I don't give refunds. Also, if you know you got a pending charge, had one gentleman trying to beat the system, thought he was smart, came to class, didn't tell me anything, and he tried to get his license and they denied it because he had a court date coming up like 30 days after the class. But he's going to beat the system and try to get the concealed carry permit before the charge hit the court system. He wasn't convicted, but once they found out had a pending charge, they froze it right there. And if that's the situation, then they're going to freeze it. They're not going to give you your license after that charge is disposed of. The applicant is eligible to own or possess or receive a firearm under the provisions of state and federal law. The applicant is not under indictment or against whom a finding of probable cause exists for a felony. You got pending charges for it might be a felony if found guilty. Applicant has not been adjudicated guilty of a felony, and this one's also been changed since 2013 because there are some felonies now where you can get your concealed carry license, but if it's a violent felon, you still cannot get it. But there's some non-violent felons that they will specify must be a certain amount of time expired before you can get your license, or you may have it expunged at a fee so you can qualify to get your concealed carry license. Now, sometimes law enforcement agencies are not up on the law, but you need to know yourself. By going to the website I've given you, that North Carolina handgun laws, they will tell you those same things and will specify for which non-violent felons you may get your concealed carry if you've had so much time expired since you had that felony. So you're not totally out of the race just because you are a felon, if it's a non-violent felon. There are some other charges may block you also that are not even felonies. We'll talk about those a little bit later on. The applicant is not a fugitive from justice. You're not on the run. Applicant is not an unlawful user or addicted to marijuana, alcohol, any depressant, stimulant, or narcotic, drug, or any other controlled substance. Applicant is not currently or has been previously adjudicated by a court or administrative determined by the government agencies whose decisions are subject to judicial review to be lacking mental capacity or mentally ill. If that's your situation, you will be denied. Consultative services to outpatient treatment alone shall not disqualify an applicant. You could have gone and sought treatment on these agencies without being blocked necessarily. The applicant has not been discharged from the armed forces under less than honorable conditions. The applicant has not been adjudicated guilty of or received a prayer for judgment, continued or suspended sentence for offenses constituting a misdemeanor under the following specific statutes or any other crime of violence. So it can be a misdemeanor in these cases here. Harassment of an unauthorized communication with jurors, violation of court orders, furnishing poison, controlled substances, deadly weapons, cartridges, ammunition, alcoholic beverages to inmates or charitable, mental or penal institutions or local confinement facilities, carrying weapons on campus or other educational property. This will bar you. Carrying weapons to assemblies and establishments where alcoholic beverages are sold and consumed. That one is obsolete. Carrying weapons on state property and courthouses. Possession and use of sale of spring-loaded projectile knives. Impersonation of a firearm or emergency medical services personnel. Impersonating officers. Communicating threats. Carrying weapons at parades and other public gatherings illegally. Stalking. Throwing or dropping objects at sporting events. Exploding dynamite cartridges or bombs. Rioting. Inciting to riot, fighting or conduct creating that threat of imminent fighting or of violence, making or using any utterance gesture, display, or abusive language which is intended and plainly likely to provoke violent retaliation, thereby creating a breach of peace, looting, and trespassing during an emergency. Assault on emergency personnel, it's a no-no. Violation of state or emergency ordinances. Violation of court state of emergency ordinances. Violation of state emergency ordinances. Child abuse. Violation of ordinances for carrying a concealed weapon. Misrepresentation or uncertification or qualifying retired law enforcement officers. Any crime of violence found in Chapter 14, Article 8 of the North Carolina General Statutes. The person is not free on bond or personal recognizance pending trial, appeal, or sentencing for a crime which would disqualify him for obtaining the concealed carry permit, trying to beat the system. The applicant has not been convicted or impaired driving offense under any of the following general statutes within the 3 years prior to the date of the applicant being submitted. That is for 3 years. Impaired driving, got to be 3 years. Impaired driving in commercial vehicle. Driving by a person less than 200 years of old, consuming alcohol or drugs. Domestic violence issues. A court in any domestic violence protective order can prohibit a party from possessing, purchasing, or receiving a firearm for a fixed time in the order. Further, effective September 30 of 1996, it was modified that the Lautenberg Amendment to prohibit the possession of firearms and ammunition, anyone convicted of a misdemeanor under federal or state law which has an element the use or attempted use of physical force or the threatening use of a deadly weapon committed by a current or former spouse, parent, or guardian of the victim, by a person with whom the victim shared a child or in common, by a person who is cohabitation with or has cohabitated with the victim as a spouse, parent, or guardian, or by a person similarly situated to a spouse, parent, or guardian of the victim. A lot of words there, a lot of technicalities there. Know it for yourself. Reciprocity. What is reciprocity? North Carolina allows residents of other states who have concealed carry handgun permits used by their state to carry concealed handguns in North Carolina. It's a great thing. For North Carolina permittees who wish to carry in other states, you may obtain the current list of those states that honor the North Carolina permit by visiting the North Carolina Department of Justice website, www.ncdoj.gov. Again, you can go to that website, North Carolina Department of Justice website, www.ncdoj.gov, and click on Crime and Law Enforcement, and a drop-down menu will appear. Click on Concealed Handguns. This will direct you to the latest information on those states that allow North Carolinians to carry in their state. Remember that while traveling other state, you are subject to the laws of that state, so please be aware of the use of deadly force that may be different as well as those places where carrying concealed is prohibited. Consider contacting the Attorney General's office of the state in which you will be traveling for the current laws of that state. So again, if you're traveling in any state other than North Carolina, you are liable for that state's laws. So go online. Like you look up North Carolina handgun laws, look up Georgia handgun laws, Florida handgun laws, Mississippi handgun laws. It will tell you whether it's honored in North Carolina. Now, generally speaking, in North Carolina, do not take your weapon above Virginia. Virginia on down, you're relatively safe. And west of North Carolina, you're relatively safe. North of Virginia, you are illegal to carry your gun up there across the border. You're going to be a felon with that weapon in your vehicle, period. Don't carry it up there. You're going to be illegal. Let me say this too. Whenever you buy or you get a handgun license, a concealed carry license, they send a message to DMV. So anytime your license plate is run, it comes back identifying you as a concealed carry holder. Now, when the police stop you, they run your license plate, it's come back as your concealed carry holder. What they don't know is at this time, is that weapon in that car? Are you armed at this time? They're going to wonder that until you tell them either or you're carrying or you're not. So when you come to your vehicle, they're going to come to your vehicle very cautiously, and they're going to approach you cautiously and have you're supposed to tell them by law if you have a weapon in that vehicle. Now, if you don't have a weapon, you don't have to say anything. But for your own safety, people, either way, tell them either way. Say, officer, just so you know, I do have a concealed carry permit. I do have a weapon on my person, and tell them where it's located. Don't try to reach for it or show it to them. If your weapon's not in the vehicle, still tell them either way, because at that point they will go a lot more at ease in your presence. Say, officer, I do have a concealed carry license, which you probably already know by running my tag, but I do not have a gun in my person or with the vehicle at this time. And they will appreciate that. Now, along that same line too, other people who drive your vehicles that's in your name, they may not know you even have a handgun. But tell them when law enforcement approaches them and tell them that, sir, this car belongs to my mother or my father, whoever it belongs to, and I do not have a concealed carry license, nor is there a gun on my person or this vehicle as far as I know. And that's what you're going to do. Now, when you're out of state, they run your license plate and they stop you. If you're from North Carolina, that state does not honor our concealed carry license, they don't have reciprocity with us, that is probable cause to search your vehicle. They probably will pull you over and search your vehicle for a weapon, which is totally illegal, because when it says you have a concealed carry license, that's probable cause to make sure you don't have it in that state where it's illegal. And also along with that people, you're up there by Maryland, New York, with that turnpike, and they catch you with that weapon, let me tell you what's going to happen to you. They're going to charge you a year for having the weapon and a year for every round in your magazine. So if you got a 10-round magazine, a 15-round magazine in your weapon, you just got a year for the weapon and 15 years for each round in your magazine. You got 15 years to do at Rikers Island. So that's non-negotiable. Now you know. Do folks do that? Yes, they do. But I'm telling you, you may get by with it for years. The first time you're caught, it's going to be trouble. I've had truckers tell me that they got stopped by state troopers in those states like that. The trooper had sympathy with them and kind of identified with them, so you know you're illegal. I can write you up. Don't bring your weapon back up here. And they keep bringing it back. You get caught, it's going to be you. So as long as you know, your eyes are wide open. Now, course requirements. The concealed carry course the individual attends must meet several minimum standards as set forth by the North Carolina Administrative Code. Those requirements are: the course must be a minimum of 8 hours long, plus the range and qualification time. So what you're going to get now in this lesson plan, the length of it may vary, but you will make up the difference when you come in person to get your written test, and what other notes I'll pass on to you, and for your actual practical evaluation. So altogether, you will get 8 hours of good, solid training. The legal block of instruction must be a minimum of 2 hours in length. The legal portion itself must be 2 hours long. The written examination is required. Right now, we will have 20 multiple choice questions we will give you, and you will score a passing score of 70% or above on this test. Don't worry about it. It's a very user-friendly test. I haven't anybody failed this test yet. Wink, wink. A shooting proficiency examination is required. The course of fire must be a minimum of 30 rounds, with 10 rounds fired from the 3-yard line, 10 rounds from the 5-yard line, 10 rounds from the 7-yard line. So we're not talking about long distance shooting, people. Statistics prove that most of the time, even in law enforcement, where there's a deadly force encounter with a firearm, it usually happens in low and limited light conditions. It's going to be about max of 21 feet or 7 yards, and it's over very, very quickly. You rarely ever get a chance to reload in these situations. So you don't have to have a weapon that fires 15 times. So again, you want to make your rounds count. Don't waste time trying to turn on all these devices you got. You need to fire this weapon effectively at short distances. We're going to teach you how to do that. The concealed carry course must cover the following topics, or does not meet the minimum state standard requirements. Legal issues, handgun safety, handguns itself, what type of handguns there are, marksmanship fundamentals, carry concealed safety issues, presentation techniques, cleaning and maintenance, ammunition, proficiency drills. You will get all that when you come for your live portion of it. Do's and don'ts of carrying concealed handguns. Your permit to carry a concealed handgun must be carried along with a valid identification whenever the handgun is being carried concealed. Now, at this point, we're going to terminate this portion of this session of the training. And thank you for listening, and hope you learned and you're even more qualified now to carry your weapon safely.